SJC-12996, Rebecca Grossman and others, v. the Secretary of the Commonwealth of Massachusetts.
Mr. Robbins, your argument, please.
Thank you, Your Honor. Good morning, and may it please the Court. Jeff Robbins on behalf of the petitioner. With due respect to the Secretary, he breezes past, glides past, and does not address, because he cannot, the simple arithmetic facts that mean that, as applied, this regimen, the regimen in place, will leave uncountable numbers of Massachusetts voters who want to vote in this consequential election and who have fully complied with the Massachusetts law providing for the alternative of mail-in voting in order to protect them from the risks or the perceived risks of a pandemic. They'll either not be able to even vote or will vote and not be able to have their vote counted, effectively bringing about the disenfranchisement of uncountable numbers of Massachusetts voters who complied with the law and who simply wish to exercise their constitutional right to vote. We submit that this is unacceptable and that it's unnecessary. It is wholly unnecessary, because as the reply brief that we filed this morning sets forth in detail, including in charts to which I respectfully direct your attention, notwithstanding the generalized, non-specific, and somewhat boilerplate assertions that it will be challenging for the Secretary to comply with deadlines if the date of, or it may be challenging if the date of counting votes is moved beyond September 1st, there are approximately 7 different reasons set forth in our reply brief why that generalized assertion is belied by the facts. These include the fact that election after election after election during the entirety of the Secretary's tenure, each and every primary that has been held later than September 1st, generally into the 2nd or 3rd week of September, without any impact on his ability to comply with those deadlines, with periods between the counting of the votes and the general election generally exceeding the 53 days between September 11th, if the court chooses that date as we've sought, and the general election. Indeed, our neighbors to the south and the north, Rhode Island and New Hampshire, are themselves holding primaries a week after ours on September 8th, with no apparent concern about meeting the 45-day deadline or any other deadline. There's no reason why Massachusetts cannot do so, especially where it has held primaries and counted votes well past September 1st every single federal primary year since the Secretary became Secretary, usually leaving less time to comply with the 45-day deadline than there will be if the court fully grants us the specific relief we seek and sets September 11th as the date on which all mail-in ballots will be received. The sum and substance of it is this: the generalized assertion that the Secretary will be challenged to have to meet the 45-day deadline, or may be challenged, depending on various scenarios, such that voters who otherwise will not be able to vote and have their vote counted can vote and have their votes counted, is, meaning no disrespect, a red herring. Massachusetts voters and families are highly challenged these days, trying to cope with a great many things, including trying to figure out how to vote in the middle of this pandemic. There's no need to tell Massachusetts voters who've duly complied with the deadlines for requesting mail-in ballots to protect their health and that of their loved ones, as the Secretary effectively does, let them eat cake. If you want to vote so badly, assuming you're fortunate enough to actually receive your ballot in time to do so, you'll just have to go out and go to a town hall and deliver your supposedly mail-in ballot in person. Just wear a mask. The fact is that there are significant communities, ones that have been particularly ravaged by this disease, the elderly, communities of color, other disabled, and all sorts of others who either cannot do this or who in any event should not, need not, be forced to do this in order to exercise their constitutional rights.
Thank you, Mr. Robbins. I'm going to turn to Justice Rowley for the first set of questions.
Thank you, Justice Gaziano. Mr. Robbins, a couple of just quick factual questions, if you know the answer. Are the municipal drop boxes inside or buildings, or are they outside?
I don't know the answer to that question, Your Honor. They have been, I have understood from public statements made by the Secretary that some may be inside, some may be outside. Of course, people will have to commute and go into public spaces either outside or inside in order to deliver their supposedly mail-in ballots under this regime.
Do you have any sense at all of how difficult it is to obtain a hardship waiver as to the Secretary's obligations to the federal government for the overseas ballots?
Thank you for asking that question, Your Honor, because I think fifth or sixth in the 7 reasons that we list is the fact that even assuming there was a risk, a meaningful risk of meeting that 45-day deadline, and as you know, we say that for 5 reasons before that, there in fact is not, at least it hasn't been demonstrated, the Secretary was able, as a matter of law, would have been able to apply for a hardship waiver. And by law, by operation of law, as I hope we have quoted, one of those bases is the date of the primary. Another one is a contested election. Now, it may be that the Secretary has waited too long to apply for that waiver. But if he has, it's evidence that he never thought, despite the fact that there was all this planning about this new legislation, he doesn't think even now that it was necessary to ask for such a waiver. But at a minimum, the Secretary should not, we submit, be permitted to invoke his own failure to act and ask for a waiver if he thought there was a real risk as a defense for the constitutional rights of untold Massachusetts voters being violated.
So we've got an issue of what level of scrutiny we're going to be applying here, but the issue isn't just simply whether or not the Secretary of State can comply with federal law, or even whether or not he's able to get the materials necessary to local officials by October 9th. Isn't the issue in considering these deadlines, and particularly that the votes be in by September 1st, whether that's, again, apply the level of scrutiny appropriate, is considering all the circumstances, whether that September 1st deadline is reasonable or satisfies intermediate or strict scrutiny.
Well, Your Honor, thank you. For the reasons we've set forth, we think that given the extraordinary burden that is being placed on a fundamental right, that the scrutiny that is applicable, as in Goldstein, where the burden, the constitutional burden was, we suggest, significantly less than exists here, we think that the right standard is strict scrutiny. However, I will say that regardless of the level of scrutiny, this scheme does not satisfy even rational scrutiny, because for the reasons we've set forth, the math simply guarantees that people will not get their ballots even in time, let alone be able to get their ballots back in time. And the math that I'm referring to, obviously, that basically dictates that even if you were to apply a rational basis test, we don't, by the way, challenge, of course, the legitimacy of the legislature, the Secretary's right to regulate elections, far from it. But here, where, as a practical matter, as a matter of law, any one of us can apply for a ballot as of August 26th, or 25th, or 24th, or 23rd, or 22nd. And we are now being informed by the Postal Service and by the Secretary himself that you can expect that even if town officials who are greatly overburdened somehow have the ability to mail the ballot out the very day that it's received, which is improbable for obvious reasons, particularly given the massive influx of these requests, that voters will not even get the ballots by within a week, let alone be able to then stand by the mailbox, complete it in the driveway, and put it in the mail and hope that the U.S. Postal Service stream gets it back in time. That, we submit, doesn't satisfy any basis, even a minimal analysis, let alone the strict scrutiny analysis that we've submitted applies here.
Thank you, Mr. Robbins. That's all I have.
Justice Budd?
Hi. My question is this. I think in the materials you mentioned that there's nothing on the mailing that indicates to voters that when the actual ballot has to be in order to be counted. Is that correct?
Your Honor, there is, in fact, I believe it may be attached to the reply brief, there is a bulletin. We attached, I think, a copy of the application itself. The application, I believe, says in bold font that there must be an application received by August 26th,
yes.
But does not say anything about the fact that it has to be received in order to be counted back in the town hall with election office by September 1st. That's correct.
And then, I'm sorry, I wasn't able to hear you when you talked about the standards of review. Normally, I just want to make sure I understand your argument that normally it would be rational basis, but because of the circumstances, is that it? It should be strict scrutiny?
Well, what we are submitting is, as we think the courts have held, and this court has held, that where the burden, the constitutional burden, is severe, is onerous, as this one is, more so than in the Goldstein case, where, from memory, the court applied a strict scrutiny test, that the strict scrutiny is what is required. What I then further said, and I'm not sure if you were able to hear me, Justice Budd, is that even, however, if you applied simply a rational basis test to this, the minimal test, this deadline is irrational. It's inherently absurd that there's this internal collision. I'm sorry?
You're saying it's not normally, but because of the circumstances we're in right now.
Yes, Your Honor.
Yes. Okay, thanks so much.
Thank you, Your Honor.
Justice Blackford, please.
Yes, counsel, one question about the August 26th date. I noticed in your reply brief, I think it's around page 10, you said that voters can get a ballot in the mail by August 26th or on August 26th. Was there any indication anywhere that voters could get a ballot sooner than August 26th?
Well, the chart in the reply brief, as the court will see, lays out the deadlines. The voter may apply, may get their application into a town hall, let's say, by August 26th. They, of course, may do so.
But they can also get it, they could do it sooner.
They can do it sooner. The problem is that if they do it on the 26th, the 25th, the 24th, the 23rd, or last week, the Postal Service and the Secretary are stipulating that it may take them a week before it's transmitted, before it's effectively returned from the ballot itself is returned from the local office to the voter. And that, by the way, discounts the unknown, which is how long it will take the local officers, burdened as they are by this influx of applications, to simply process and put it in the mail.
I understand. Do you have any of the cases that you looked at with regard to the level of review that we should apply when a fundamental right is burdened? Do you have any particular voting rights cases, or are they just by analogy that would argue for strict scrutiny?
If I'm correct that in Goldstein there was an indication that strict scrutiny was required, and I may or may not be correct about that in candor, that involved a burdening of voting rights or of election rights, significantly, in my view, less serious than existed here, in that there the court recognized the burden for candidates to get on the office get on the ballot by getting signatures and getting votes certified. Here, what we have is, unless I am missing something and the Secretary has not contended otherwise, we have the virtual guarantee, the mathematical certainty, if I can say so, that there will be untold voters who, according to the Postal Service and according to the Secretary, won't even get their ballots in time to mail them in. And if they do get their ballots, won't even get their ballots before September 1st. And if they do get their ballots before September 1st,
right. I understand the deadline issues and the dates. I have no further questions. Thank you.
Justice Capper, please.
Mr. Robbins, it's a right to vote, right? It's not a right to vote by mail. That's the constitutional right, right?
It is a right to vote, Your Honor, but I point to the First Circuit decision and the Attorney General's own filing in federal court on Friday as evidence that here it's effectively the same.
Well, but it's not really, because the statute provides a dramatic enhancement of the right to vote, correct? It's in response to the COVID crisis, the legislature created a plan that dramatically increased our ability as citizens of Massachusetts to vote, right?
I look at it not as an enhancement of the right to vote, but as a protection of the right to vote, understanding that the pandemic and its effects will otherwise make it impossible or very difficult, will in any event burden the right to vote.
But again, you're saying the statute on its face is unconstitutional, right?
No, I'm saying that as applied here, under these circumstances, where given what has now been said as of July 30th by the Postal Service and by Secretary Galvin for the first time on Friday, where we are looking at a scenario in which it will take a week in either direction. Under these
So it'll take a week for the person who waited till the end, right? The person who's requesting it on August 26th. But that person's also got a bunch of options, right? They can track their ballot to see if there's a database, right? They can monitor whether they received the ballot, correct? They can see where it is in the mail. And if they haven't gotten it, they have other options, right? They can,
assuming they have computers and are using it and are computer literate. But I have to take issue with one premise of Your Honor's question. It's not a week for somebody who applies on August 26th. It's a week whenever they apply. It's a week period.
If they've had since July, when the ballots went out July 23rd, according to you, they should have gone out earlier, but they went out July 23rd. Is that correct?
Not the ballots.
The
applications for ballots. The applications for ballots. So they were permitted to whenever those arrived, voters were given the chance to apply to send in their application for a ballot.
Right. And again, you have, and factually, have all of your clients now received the ballots? All of yours, the ones?
Yeah, yes. All the petitioners, since
all the petitioners
the petition was filed,
they've all gotten there.
Several affiants have still not received them. One of the petitioners, a 98-year-old woman in a home, received hers on Saturday. So she, as with God knows how many other similarly situated people around Massachusetts, have to find a way to even get out to mail their ballots in time to get it back. And as I should say that the Secretary is saying that the process of ballot back and ballot in one way and ballot the other way should be expected to take 2 to 3 weeks, which would mean that half of that would be 10 days or so.
Okay, but so let's then, the Secretary also has, you need the right to challenge the primary as well, right? That takes time. The Secretary points to a bunch of deadlines that need to be met. Aren't those reasonable deadlines? And isn't it important that our soldiers overseas get their ballots in a timely way too, so they can vote? Aren't all those reasonable requirements to be imposed?
The 45-day deadline, which is a federal deadline, it certainly is reasonable. The problem is that there's no justification. There's no
But it's
merit.
not a 45. Don't we have to go backwards? We have, say your client is in a dead heat and there's a challenge. That's going to take time to resolve too, right?
Well, it will take some time to resolve, but I will point to, I think.
And if we have, for example, a challenge in the Senate, which is going to involve the entire state, that could take time to resolve, right? Doesn't the Secretary need to build that into his time frame?
The Secretary can factor it in. I'm simply pointing out the two very prominent recounts bookending the Secretary's tenure in which there were those recount challenges. The 1996 one with Philip Johnston and Congressman Delahunt, and the one 2 years ago where there were recounts, and the recounts were completed, and there was no, 2 years ago by September 17th, in 1996 later, and there still was no evident impact on the Secretary's ability to meet that 45-day deadline. So the speculative thought that there may be recounts, which I credit, there may be and there can be, but the fact of the matter is that when there have been such recounts, the Secretary has not had any, as there have been over the course of the last 25 years, with primaries taking place later in each case than September 1st, the fact of the matter is that the Secretary has had no difficulty, even with the recounts, complying with the 45-day deadline.
I have no further questions. Thank you.
Thank you, Your Honor.
Justice Link? Justice Link, do you have any questions?
I didn't press my,
Oh, there you go.
am I off mute now, finally?
You are.
Oh, can you hear me?
Yes, we can.
Okay, good. I'm sorry, I muted myself. Good morning, I do have a couple of questions. The first one being, could we be clear on what it is you're looking for? You're looking for relief that would, say that, as long as the ballot was, postmarked on the date of the election or before the date of the election, September 1st. For 10 days after that, it could be counted, right?
Yes, Your Honor. We're asking for the specific, narrowly tailored relief. I must say, less narrow than the court might on its own consider providing, and that is that ballots that are postmarked as of primary day, but received up to 10 days thereafter, be counted. The 10 days are based on A, the 7 days minimum that the Postal Service and Secretary Galvin have both said it may take, plus a 3-day window to account for the fact that they say that it's a minimum of 7 days.
Okay. Now, secondly, the question I had to do with the statute itself that was passed by the legislature in the midst of the pandemic. They were quite aware of the fact that this was a pandemic, right, when they passed this legislation in 2020?
No question about it, Your Honor.
Okay, and that's the reason probably for it, huh?
Yes.
Okay, and they at that time did not make any provision for this problem that we're encountering now, right?
Well, I will agree that the August 26th, you can apply until August 26th, but you still have to get your ballot in by September 1st. Was not necessarily the best move then, with all due respect, but in any event, we are where we are. Yes, they did know, of course, about the pandemic, and why it is that this was not provided for, given what might have been expected, is beyond my area of expertise.
Then we're going to have the same problem with the general election on September 3rd. On November 3rd, a ballot is mailed, must be postmarked by November 3rd, and must reach a local election office by November 6th to be counted. That's what the legislation provides, right?
Yes, there is the ability, as I understand it, for certain categories of overseas and military voters to postmark their ballots by the date of the general election, and have them counted as long as they are received within 10 days thereafter. And so the relief that we seek patterns that. I note if you'll...
Yeah, because you're asking for 10 days, and the legislature provided in that situation for 3, right?
I'm sorry, Your Honor, I couldn't...
You're asking for 10 days when the legislature provided for 3, even in the general election, right?
We're asking for 10 days from the date of the postmark on September 1st until September 11th, when the ballots would have to be in. The court may decide, of course, to grant a shorter period of time, September 8th, consistent with New Hampshire and Rhode Island, but that is what we are seeking in an effort to maximize the number of people who will be able to avail themselves of the mail-in feature.
It has to be postmarked, right, by a certain date, by the date of the election, September 1?
Yes, we're asking that voters would have to postmark their ballots by September 1. That's correct.
How could they assure that would be postmarked on September 1? How could they assure that?
Well, you are right in the sense that you are, I think, pointing out that there are still voters who will be unable to do that because they may have complied with the law and applied by the 24th or 5th or 6th and not even get their ballots in time for September 1st. And you're correct. The conservative, the narrow, relatively narrow, the limited relief that we've sought, mindful that the court wants always to balance the interests of people, of the parties involved, and adopt narrow relief. You are correct when you suggest that there are still people who will be disenfranchised. And so one way you may be wondering, well, how can we reduce further the number of people who would be disenfranchised because they won't even get their ballots back by September 1st. And one thing that the court may wish to suggest in exercising its equitable power would be, we have not asked for it, because we wanted to be as narrow as possible in seeking this relief. But the court could, for instance, extend the date of postmarking the ballots till September 4th, with the requirement on the back ends keeping the same of September 11th. That would surely increase the number of people who could actually participate. Why? Because the Postal Service is saying if you apply by August 26th, it may take a week or more between the time that the ballot is mailed to you by an overburdened postal office and the time that you get it. So to the extent that you're suggesting that there are still people under the relief that we seek who will be disenfranchised, I submit that you're correct. And if the court wishes to provide more robust relief by expanding the number of people who will not be disenfranchised, then permitting voters to have their ballots postmarked by September 4th and still have the votes counted as of September 11th would do that and would not affect what we say is not a burden on the Secretary as a practical matter based on the history at all.
Okay, well, it's nice to be correct about something, but I'm not sure that was really what I meant. Okay, I was asking a simpler question, which how can we ever be sure that something's going to be postmarked on a certain day? Let's say I have a ballot and I want to hand it to my mailman. How do I know it's going to be postmarked as of that day?
I mean, we don't.
We don't. None of us do at any time. I mean, this is not necessarily pandemic related. This is just any time. I mean, we never can be sure something is postmarked on a certain day, right?
There is no guarantee the Postal Service will succeed in delivering ballots in either direction.
Delivering. I mean, what does postmarking really mean, though?
It means, as I understand it, that it's received and the processing within the mail.
Put a stamp on it of some sort, huh?
A stamp on it, yes.
It says it's postmarked a certain date. And
Yes.
That's the date the post office got it. It's not necessarily the same date as the person putting it in the mailbox, though.
Far from it.
So in other words, in order to be sure that something is being postmarked on a certain day, you have to actually hand it to the post office person at the post office and watch them stamp it.
You are correct, Your Honor.
Okay. All right, I don't have anything else. Thank you.
Just a few questions, Mr. Robbins. And you answered my question, because the whole 10-day extension, you explained that it doesn't seem to be pulled out of a hat. It's based upon what is happening in Rhode Island and the other states, and also the 7 days plus 3 for comfort level. But let me ask you, on the level of scrutiny, if we decide, as Justice Kafka asked you, that there is a right to vote, this is a right to mail-in vote, and I know you think they're not distinguishable, but if we apply rational basis, isn't there deference due in that situation to the legislature and the Secretary of State as far as the timing goes?
Your Honor, the best way to answer that is to point to the First Circuit's decision of 2 weeks ago in the Common Cause case. Quote, "The burden imposed by these requirements in the midst of a pandemic is significant. Taking an unusual and, in fact, unnecessary chance with your life is a heavy burden to bear simply to vote." And so we submit that, given what the First Circuit and other courts, and effectively this court in Goldstein, in talking about the effects of the pandemic, and the Attorney General herself in the federal filing that she made in federal court in Pennsylvania, which should be attached to our papers, that the burden on this vote is so high that there isn't deference to simply, there certainly isn't deference in any event to simply say conclusorily, we may be challenged. At a minimum, the Secretary ought to be able to demonstrate that there's a real, serious, meaningful likelihood of being unable to do it, which they do not do, and which they'd be hard-pressed to do, given...
Well, I think the deference is not in, because obviously we're not dealing with good solutions, with a perfect world here, which we're dealing with the imperfect. And the deference that I look at is whether or not the Secretary can, in good faith, comply with this federal mandate. That's the deference I speak of.
And Your Honor, I'm acutely aware that that is the principal argument, and that is why we laid out all of the reasons why the generalized, we may have these deadlines that may be a challenge, that doesn't essentially cut it, if you pardon the vernacular, given what we lay out, I think pages 11 forward in the reply brief.
The shortest time frame I think I saw from the chart was 49 days.
Yeah, I think that's right.
There's a few of them that there were a few of them that were 49 days, but that was the shortest time frame, if I remember right, correct?
Right, and what we actually, because we realized that just putting the primary date, showing that the primaries are held after September 1st, was only one half of the equation, that you would want to know how many days before the 45-day deadline between the primary, between the counting.
And the 49 days is just a product of the vagaries of the calendar. Nothing magic to that, right?
No, there's no magic. The 45 days is the federal statute.
Right, and the 49 days is because of how the calendar laid out, correct?
Our point was that in most of the last 12 or 13 elections, there has been less time between the date of the counting and the general election, and therefore less time between the primary and the day.
I assume you may be sensing my discomfort in telling the Secretary of State, don't do 53 days, do 49 days.
Oh, I'm not saying that.
Given the deference that we should probably owe to the elected official in the legislature.
No, I'm not saying you should or shouldn't do. I'm simply pointing out that in the vast majority of the election primaries in the last 25, 26 years, there has in fact, even if you picked September 11th as the date when the votes were counted, and not September 8th, as you may choose to do or may consider doing, as Rhode Island and New Hampshire do, there is more time before the mail has to be sent out overseas than there has been in the majority of the last 12, 13 elections, the entirety of the Secretary's tenure. That's the point of the 3 days.
So in the overburdened town clerks that you point to in the mailing process, these are the same overburdened clerks that will be responsible for the recount, correct?
Well, you mean the recount, or is the court referring to the counting of the ballots as they come in after September 1st?
Both, actually.
Well,
because we're dealing with these workers who are going to be working under very extreme circumstances and very trying circumstances.
Well,
we should be responsive to that, correct?
Yes, of course. And I have not heard I've not seen any evidence that it will be difficult to simply count as they come in on every day between September 1st and September 8th or September 11th, the ballots that come in. I haven't seen any suggestion or showing, certainly, that imposes much of a burden at all on anybody counting votes.
And I guess the bottom line is to be safe in your view and to count every vote in your view, we should at least go to September 8th.
I do think that a week is consistent with New Hampshire and Massachusetts. That New Hampshire and Rhode Island. Who managed to do it, and even that, I point out that Secretary Galvin has been running these elections without running into that 45-day deadline past September 8th for most of the last quarter century.
And then a recount couldn't start until September 9th in that event. Someone couldn't call for a recount because you wouldn't know the election results until September 8th or 9th, right?
8th or 9th, that's correct. And if there is, in fact, a recount, a wholly speculative matter now, and if there is an issue about when it has to get done, either this court can set a deadline for it now, or another lower court can deal with it if that becomes an issue where the appropriate parties are concerned. I point out, incidentally, that the deadline for recounts now, I think we've said this, is September 12th for completing recounts.
Complete them, right.
And so...
What's the deadline to file for recount, Mr. Robbins?
I believe it is 3 days after, so September 4th. So in fashioning a remedy, the court could push the deadline for that back 2 or 3 days as it saw fit, if it even be, or wait to see if it actually materialized and then deal with it then.
Thank you, Mr. Robbins.
Thank you, Your Honor.
Let me now turn to Sturman.
Thank you, Your Honor. As the administrator of the Commonwealth elections, Secretary Galvin takes very seriously his responsibility to ensure that as many voters as possible can participate in elections. And in light of the public health emergency caused by the COVID-19 pandemic, the Secretary and the legislature have made it easier and safer for people to vote in Massachusetts. In 2020, for the first time ever, voters can vote early in both the primary and the general election, either in person or by mail and with no excuse required. The in-person early voting period for the general election has been doubled from 10 days to 20. Every voter in the Commonwealth was mailed an application for a ballot. Ballots can be returned by mail or by hand to municipal drop boxes, early voting sites, or local election offices. The Secretary is making sure that poll workers across the Commonwealth have personal protective equipment, and he has advised local officials on how to safely conduct in-person early and election day voting based on input from public health officials and the Centers for Disease Control. The combined effect is that Massachusetts voters today have more safe options to vote than ever before. The landscape here is not like the one that the court faced in Goldstein, where the legislature had not yet acted to adapt the statutory rules to take account for the pandemic. Rather, here, they have made significant efforts to expand voter options. But while expanding this menu of voting options, the legislature, knowing all the things that need to happen between the nominating primary and the federally imposed September 19th UOCAVA deadline to transmit ballots to military and overseas voters, made a judgment call that ballots need to be received by September 1st in order to count. And this is because the Secretary needs to allow time for recounts, objections, and other safeguards before we can know for sure who was nominated at the primary, and the Secretary can move to doing what needs to be done to have an orderly election in November. I would urge the court to use caution in taking its guidance solely from the dates of previous year's primaries. Remember that the 45-day deadline as a matter of federal law did not exist until 2010. Whether or not the petitioners or this court agree with every choice the legislature made in enacting these reforms, those choices were rational and they passed constitutional muster. The relief that the petitioners seek would prevent the Secretary from complying with the federal law requirement to send ballots to military and overseas voters by September 19th, and would interfere with the ability to administer the general election. Where the deadline for ballot receipt does not pose significant interference with voters' ability to participate in the primary election, and where adopting the remedy proposed by the petitioners would significantly interfere with opportunities for voter participation in the general election, the petition should be denied. At this time, I'd be glad to take the court's questions.
Thank you. Justice Slowey?
Thank you very much. So when I hear your argument, you seem to be saying, well, the Secretary of State, understandably, his concern is that nobody be disenfranchised, but certainly as few people as possible. And we're dealing with legislation passed in 2020, cognizant of the pandemic. And sure, there's a concern. Absolutely, there's a concern that if somebody waits until August 26th to request a ballot, that if they decide to return the ballot by mail, that may not get in on time. But we have to take that scenario in the context of all potential voters and look and see whether or not this statute was reasonable in requiring that the votes be in by September 1st. Is that basically a position?
That is our position, Your Honor, that even the voter who waits until the very last moment to submit a ballot, a non-in-person ballot, for lack of a better term, that person is not disenfranchised. That person may be not have the entire menu of options available to them, the menu of options that the legislature created to expand voter opportunities this year, but they absolutely have opportunities to make sure their vote will be counted in this year's election.
Right. So August 26th, the legislature could have said August 16th. But that would have made it more certain that the vote, if mailed back, would have gotten there on time, but the legislature didn't pick August 15th, August 16th, August 10th. They picked August 26th. And perhaps that's not unreasonable because it gives the voter more time to decide. But if you wait till August 26th, then your options of how to vote may not be the same as if you had made your decision on August 12th. Do you understand what I'm saying?
I think that's exactly right, Your Honor, in that it's clear from the overall provisions of the 2020 law that the legislature was very much interested in taking multiple approaches to expanding opportunities for voters to safely participate in this year's election. And I think it would have been rational when setting the deadline for application requests at August 26th to try to push that, to try to inch that as late as possible in order to allow as many voters to take advantage of that as could.
But if, of course, if the voter takes that option as late as August 26th, then they may have fewer options as to the menu of ways to vote with this 2020 statute.
I think that's right, but that voter is probably still got more options than if the legislature had set the deadline early, say at August 15th, and the voter had not yet decided by that deadline that they wanted to request a mail-in ballot. At that point, the voter who decides on August 26th that they don't want to vote by in-person means will have missed the deadline. So the legislature, the provision and the date that the legislature chose has still had the effect of maximizing voter opportunities over a deadline that might have been set earlier.
Okay, thank you. I'm all set.
Justice Budd? Okay, thank you, Justice Budd. Justice Budd?
Yes, hi. I guess I'm just trying to figure out, and one of the concerns I have is that voters were not on notice necessarily that there could be a situation where their vote might not count, even if they abide by the guidelines presented in the application. Is that fair to say?
I don't think that's quite fair to say. It is true that the application did not contain information about the vote receipt deadline, but the ballot materials that go out to the voters very prominently features a warning as to the date and time by which your ballot must be received in order to count, so that a voter, when making the decision about how to return their voted ballot, is very much aware of what time it must be received in order to ensure that it counts and can make the decision about how to return that ballot accordingly.
Yeah, I mean, I mean, just anecdotally, I know of people who haven't yet received their ballots. I myself, after hearing all of the concerns about the Postal Service and whatnot, I was going to request a mail-in ballot, and then it sounded like, gee, that may not be the best way to go. I don't feel comfortable. I don't feel like that's gonna work. And you're confirming to me that that in fact may very well be the case. So I'm just trying to figure out, what are we to do about the fact that we've got all of this going on? I understand that this legislation went through post-pandemic, but we didn't necessarily know that there were going to be all of these problems with the post office. Isn't that fair?
So I guess I would offer a few things in response to that. One is that by way of numbers, although I don't doubt that there are plenty of anecdotes about folks who experienced a delay in receiving their ballot, I can report that at least as of 10 a.m. this morning, upwards of 97% of requests for mail-in ballots had been fulfilled, and it's changing by the minute, such that we expect by the end of the day we'll be at about as close to 100% as we can get, understanding that we're still receiving requests. So I think there's not significant cause for concern there.
Just to stop you there, just for a second, just to put on the record.
Sure.
One person I know received the wrong ballot, so there had to be time built in to get a new ballot. Do you know what I mean? So all sorts of things are going on, but I do hear you in that the office is trying to get the ballots out as quickly and effectively as possible. I'm sorry, kind of
No, that's no problem at all. The other thing I'll point to with respect to the Postal Service issues is that while it's true that what's going on with the Postal Service now could not necessarily have been anticipated earlier this summer when the 2020 law was passed, it is also true that the Secretary has taken steps to ensure that those changes in Postal Service operations will not affect Massachusetts voters. So one of the changes to the Postal Service operations has been the way they treat election mail that is not postmarked using first-class postage. And so those may not be may not be treated with the same speed with which first-class mail or election mail has been treated by the Postal Service in the past. That is an issue that should not affect Massachusetts. The Secretary has all the ballot applications went out by first-class mail, and the ballots that voters receive are being sent via first-class mail. The envelopes with which they can return them to their local election officials are postage prepaid with the first-class mail rate. So the Secretary has done what he can within his power to ensure, to pay for that additional postage and to ensure that the election mail gets treated in an expeditious way by the Postal Service.
Okay, thank you.
Justice Seifert?
Yes, thank you. Is the only challenge created by the proposed extension the problem that would occur if there is a recount, or are there other challenges presented to the Secretary?
The recount is a large part of the challenge. There is also an opportunity for people to file objections with the State Ballot Law Commission, objecting to a candidate's placement on the general election ballot, and those have to be heard and resolved as well. There are other things that have to take place, the resolution of provisional ballots. If somebody casts a ballot and their registration status is uncertain at the time they cast it, that needs to be resolved. But the longer time periods, the things that are more complicated and more time consuming to resolve are the recount and the State Ballot Law Commission objections.
Thank you. One more question. Do you agree with the characterization by the petitioner in their reply brief that the Secretary has met shorter deadlines in the past and that this is not a big deal? That in terms of the number that you've met shorter deadlines in the past.
I don't agree, and actually the chart that the petitioner submitted with their reply is quite helpful as an illustration of that. So if your honors look at that chart, you'll notice that in all years 2010 and prior, the number of days between the primary and the general election was the same. It was 49 days, and that's because our statute requires that the primary be held on the 7th Tuesday preceding the general. So that's why it stays fixed at 49. But something changes, you'll notice, in 2010, and the reason for that change is that the MOVE Act imposed the 45-day federal law deadline for the Secretary and local election officials to transmit ballots to military and overseas voters. In 2010, because that requirement was new, Massachusetts, as well as some other states, did receive a waiver of that deadline, which is why the time period remained at 49 days. But you'll notice that for every election since, there has been a longer time period between the primary and the general election, and that is because special legislation has been enacted in every biennial state election year since 2010 to move our primary date earlier so that we could comply with federal law. So that's why those numbers go up, and you'll see that there are also differences in presidential election years. Turnout is higher, there are more ballots to count, and any recount would be more onerous.
Thank you. I have no further questions.
Justice Chapter.
Yes, so tell me about how the lock boxes, what does the statute say about lock boxes, and what factually do we know? Does every town have a lockbox? Are they required to?
The law does not require every municipality to have a contact-free drop box, although we know that many of them do. As best I can ascertain, there are at least about 200 of them across the Commonwealth as is. That is not the only way to drop off your ballot if you don't want to put it in the mail and you don't want to vote in person. The legislation also required that you can turn your mail-in ballot in at any early voting site during early voting hours. Those happen for 7 days before the primary and for 20 days before the general. You can also hand it to your local election officials. And so while those options are not quite as contact-free as putting it in a metal box outside a building might be, they are certainly come with less contact than one might encounter voting in person. And given the traffic we've seen at early voting sites and the widespread availability of dates and times for early voting, one is likely to encounter far less human contact at those sites than they would at, say, the grocery store.
The other question I have relates to, I mean, this is going to be the first time in history, right, that we're going to have this level of mail-in voting. Is that correct?
That's right. This is the first time that one has been able to vote by mail without an excuse in Massachusetts.
So, and I take it based on, I mean, I read it, again, I'm reading the Washington Post today and the Globe today, says that they're going to be a whole different set of potentially of challenges to mail-in voting. Does that also justify sort of strict compliance with this September 1st deadline, meaning that there may be a more robust type of challenge to votes this time that haven't proceeded in the past? Is that fair to say?
I mean, certainly if that were to come to pass, that would place additional strain on the already limited time that we have to do what needs to be done between the primary and general, yes.
Meaning that, again, first time in history we've ever dealt with mail-in voting, and the recount and challenge process may be more complicated than it's been in the past. Again, is that fair to say?
I think it's fair to say that it may be more complicated, both because this is the first time we're doing this, because as we sort of described in our brief, the procedure followed for the 2018 recount in the 3rd Congressional District. Obviously, it can't, if there is a recount this year, it won't be able to happen in exactly the same way because of the pandemic and the need for social distancing. Right. And it also may be that those procedural options, that more people choose, that we're more likely to see more recount requests or more objections at the Ballot Law Commission because this is the first year we're doing it in this way. It's difficult to predict.
And my final question is more sort of, you know, part of what we're trying to do is educate people what the options are. So you're a voter who's not received you've requested, you're a person who's interested in mail-in voting to avoid, you know, interpersonal contact. It's now August 24th. What are your options to preserve your vote? Just, this person doesn't have their ballot yet. What can they do right now and under the law that the legislature has passed to make sure they get to vote?
If that person has not yet applied for a ballot, they can still do so, and they can drop that application off with their local election officials. If they have already applied for their ballot but have not received it, they can inquire with their local election officials or with the Secretary of State's office and check status. It is also true that worst case scenario, if somebody is not certain whether their mail-in vote will be counted, although they might prefer for obvious and understandable reasons to avoid human contact, they can still go in and vote in person at an early voting site at which there ought to be less traffic and fewer people, or absolute worst case scenario on election day. So your vote will only be counted once. If you're not sure, either you check the website and you're not certain whether your vote has been received, or the website indicates that your vote has not been received and you want to make sure that your vote counts this year, you can go vote in person at an early voting site or on election day.
And if you send in your ballot, and I looked at this sophisticated tracking system they've developed, the Secretary of State has developed, and it indicates your ballot has not been received yet. And that happens over the next couple of days. You can still go try to vote, I take it. if you don't know if it's been received? I'm just trying to figure out how do you protect yourself if you don't show up on that database?
You can
or you don't trust that database?
I'm sorry, Art, you can absolutely still go vote in person at either an early voting site or at your regular polling location on election day if that website does not yet indicate that your ballot has been received.
Okay. Thank you. That's all I have.
Justice Clay?
Yeah, I was hoping you could go over that chart with me again, because I'm not seeing exactly what you said here. After 2010, you said there was a change, so it wouldn't be 49 days, but it seems to me that if we have September 1, 2020 to November 3, 2020, that's 63 days, and it was shorter than that in 2014, it was 56 days, right? Shorter than that in 2016, it was 61 days. And September 2018, I'm not sure because of the difference in the way it was done here, because they're putting in between the recount and the general election as opposed to the days between the primary election and the general election date. But I'm assuming that's probably very similar to what it was in 2020, right?
Yeah, so the duration is, I suppose, marginally shorter in 2016 and 2014. It's important to remember that 2014 was not a presidential election year.
2016 was, though, wasn't it?
It was, but there's a difference of only 2 days between the duration.
Yes, but 2 days. 2 days is still 2 days, right?
In 2018, there was only, by the time the recount was finished, I'm just checking my dates. 2018 was, again, not a presidential election. Turnout was lower. And I'll have to count the number of days that we had in 2018 because it's expressed a little differently on this chart. The number that's given is the date following the recount.
Right, I understand that. That's what I'm saying. It seems to me it's probably arithmetically probably similar. September 4th to November 6th is probably not too that different from September 1st to November 3rd. I don't know how much. I haven't done it again, but it's not that important. I just want to make sure I was understanding you that in fact, after 2010, there was still some times when it was, less than what it is right now.
Yes, I'm actually calculating 2018 as the same 63 days as 2020.
That's what I thought, yeah. But okay, so you still have 2016, you still have 2014. 2012 was also a little bit shorter. So I'm not sure I understand what your point there was. That 2000 you were talking about the contract to 49 days, I suppose.
Yes, exactly. That essentially the comparison value of the dates or the duration of time 2010 and previous is very low because the situation was far different in those years. We did not have the 45-day federal law deadline by which we need to transmit ballots to military and overseas voters. So that's why the dates from on this chart from 1996 through 2010 are showing a duration of just 49 days, and then you see that they go up in the years since when we've had to comply with that 45-day deadline.
Yeah. Let me ask you a question. I mean, I suppose, though, we're not talking about mailing this to the feds, are we? We're talking about electronic transmission?
So some do electronic transmission and some do by mail.
So we rely on the United States Post Office to meet the 45 days?
Yeah, so it's actually at the voter's request for the military and overseas voters. So they can ask for it electronically or they can ask for it by mail. Yes, obviously we've got to rely on the Postal Service to get those ballots where military and overseas voters ask for them by mail to them as well.
Still a week away. Now, the thing is, I asked a question before about the date of the legislation this year. I mean, it was surely post-pandemic, but it was certainly pre-knowledge of the post office difficulties, right?
I believe so. I think it was enacted on July 6th of this year.
Yeah, so it's not like that is really going to answer the question whether the legislature really anticipated this, because even they did 3 extra days for the general election, right?
They did give 3 extra days for the general election because what has to happen following the general election is different. The constraints on the Secretary and on the Commonwealth are different. There are still some that exist after the general election, but they're different than what has to happen after the primary in order to quickly pivot and be able to safely administer a general election.
What about the Lori Trahane's business that they keep bringing up? That was quite late and it was quite contested, wasn't it?
I'm sorry.
Did you still manage to do it, Lori Trahane?
Yes, the 2018 recount.
Yep.
Yes, that was quite contentious and a labor-intensive recount. We have reason to believe that the number of votes that will be cast in the 4th Congressional District this year will far outpace what was cast in the 3rd Congressional District in 2018. And when you add in not just more ballots to recount, but also the additional constraints of social distancing and the pandemic, as laborious as the recount was in 2018, we would expect that any recount that would occur this year would be even more complex.
Yeah. You know, Justice Bud is not the only one who has anecdotal information. I suspect all of us do, about people who have not yet received their ballots. And that is the problem. I mean, if you can't even get your ballot in now by mail, that's a problem, isn't it?
I agree that it's cause for concern. Although as the numbers are
you couldn't be sure that it would be postmarked, could you? I mean, what is your view about what postmarking means and how it's achieved? How can anyone ever be sure of the postmark?
I think Your Honor was exactly correct when you spoke with Mr. Robbins to say that the only way to be sure of a postmark is to walk your piece of mail into a post office and watch them apply the postmark stamp. It is correct to say that if you put it in your mailbox or in a blue mailbox on the street or hand it to a postal worker, it's probably not going to get postmarked, my guess is, until at least the following day.
No. Okay, I don't have anything else. Thank you.
Well, I'm one of the 97% who did receive a ballot. So let me just ask you, does the potential for disenfranchisement, given all the uncertainties out there, lead to strict scrutiny analysis? How do you get to a rational basis with that in the air?
So I don't think it does, Your Honor, and that's in part because I disagree with the idea that anyone is disenfranchised by the deadline. So while it's true, as we spoke about earlier, that someone who waits until August 26th to request a ballot may have fewer options available to them among the menu of options that has been provided by the legislature to get their ballot back on time, they do still have options. That voter has not been disenfranchised. They may just be more limited in how they can return that ballot and ensure that it is received in a timely manner by their local election official.
I should know the answer to this, but could you please educate me on, with respect to the decision that ballots should be received by mail by 9/1 to be counted? That's not in the statute. That's something that the Secretary of State came up with, correct?
No, Your Honor, that is in the 2020 statute.
That's in the statute that have to be received to be counted?
That's correct. The 2020 statute contains both that deadline at 8 p.m. as well as the 3-day deadline for the general.
Okay. I should have known that. Thank you.
Yeah.
And I interrupted you. Please proceed with your answer.
With respect to standard of review, again, I think part of the reason we have a fundamental disagreement with the petitioners over the level of scrutiny is because we disagree that any voter is per se disenfranchised by operation of the deadline, but also because, as the court well knows, in the context of election cases, there is a sliding scale by which the court determines the appropriate level of scrutiny. And the question that is asked to ascertain where the level of scrutiny ought to be on that sliding scale is whether the provision at issue creates significant interference with the voter's ability to exercise the franchise. And as we've described in our brief, that's simply not the case here. Goldstein was a very different case. That was earlier on in the pandemic when the legislature, in the ballot access context, had not yet acted to adapt the ordinary statutory requirements to account for the changed conditions of the pandemic. That's quite different than what we have here. Here, the legislature has dramatically expanded the menu of options available to voters so that I don't believe it can be fairly said that any particular aspect of that menu creates significant interference with the voters' right or ability to exercise their franchise. We're now looking at sort of minor questions as to whether the August 26th deadline ought to have been a day earlier or a day later. That's very different than the question that the court had in front of it in Goldstein, where candidates at the time were still subject to pre-pandemic rules. And so, as a result, when you look at the significant interference question in the context of all of the menu of options available to voters, it's clear that the court ought to be exercising rational basis review here rather than strict scrutiny.
And your argument is once we get to rational basis, the issue then becomes how the secretary is able to comply with federal requirements, which leads to the longer time frame. Right.
That's part of it, but also the reasonableness of the legislature's judgment that August 26th was an appropriate deadline. I know you may not know the answer to this, but was part of the rationale for the deadline to be set for the same day as the election at 8 p.m. to incentivize people to mail in early? I don't believe that's the case, Your Honor. I believe that that deadline was motivated by exactly what we've been discussing here today, which is the post-primary deadlines and everything that needs to occur in order for Secretary Galvin to administer a fair and orderly general election.
Right, but we can't expect that if someone was to mail on 9/1, it's postmarked on 9/1, it's not going to get there the same day. If you're mailing something from, Pittsfield, it's not going to get, right?
Right, and that's why, if a voter has requested a mail-in ballot,
I'm not going to pick on the Pittsfield Postal Service, but anywhere, not necessarily is going to be received the same day if it's dropped in a mailbox.
I think that's right, and that is likely part of the reason why the legislature created the opportunity to return your mail-in ballot to an early voting site or to a polling location or your election official. So that if, for example, you received a ballot by mail, you haven't decided who to vote for, or you just get it on August 30th, and you want to make sure it gets to your local election official by the deadline, you are not limited to just a mail-in option for returning the ballot.
Right, so if I wait to the last minute and I drop it into a mailbox, I just don't know if it's going to get to my polling place by then.
If it's a mailbox, yes. If it's a drop box, one of the municipal drop boxes, then you don't have to worry about it. If it's a postal service mailbox, yes.
Okay. All right. That's all the questions I have. Thank you very much. Let me just remind the justice if we could have Sombo or start the call at 12:15. But thank you, counsel.
Thank you.
Thank you.